Good morning. What will happen to your photos and other digital assets? Most of us don't think about that sort of thing, but it is a problem. It's a significant problem, in fact, and most of our donors are not aware of it. What happens at death, or if you become incompetent? Access to your digital assets is going to be lost because those terms of service agreements that every one of you read word for word for word says it's between you and the company and nobody else. It prohibits access by anyone. That means that your executor, your trustee, your fiduciary doesn't get access even if you give them the username and password. And of course, you'll never do that because you'll never remember. And the executor or trustee is potentially liable. Now, the courts are not going to help because the laws have not kept up with the digital age. You accepted those terms of service agreements, so that's it. And the average person has 90 digital accounts, some more, some less. But the fact is that our whole lives are moving online. Our photos, our emails, our social media, documents, bank statements. Think of that IRA that you had 10 years ago, that you don't get printed statements, but you get an email reminding you about it, and nobody can access that email. There's a solution. Uniform Digital Fiduciary Digital Assets Act, recommended in 2015, is now law in 42 states. It's expected to be law in virtually all states very soon, and it's designed to address this critical need. Now, what happens is every state has got to adopt this, and every state can amend or adjust, so it will vary somewhat by state. Now, I served a couple of terms as a member of the House of Representatives in the Maine legislature, and I can tell you that every uniform act that came along, we fiddled with it, so you're going to want to check in your state. But the legal default remains no access after death or incompetency because the terms of service says it's not there, unless you explicitly authorize your fiduciary in writing to have access to this, and you can change your mind at any point. If you do this, you're fine. The fiduciaries are your executor, your trustee, your power of attorney, and your conservator or guardian. Those are the positions, and of course, anybody can be power of attorney. So you can grant access to this, and you should. Now, why is it important? Because very few of our donors understand the problem exists. Once you tell them, once you explain it, instantly people get it. It's a really important reason to update your will or trust because we have so much that has gone online. There's so much that's now digital. It's a great excuse to talk with donors about wills and trusts. It can be a really strong motivator, and most adults don't have a will, and most people who do have a will, it's outdated. It needs to be updated, and we need reason to push. We need reasons to encourage people to move. So why raise the issue? Help your donors. It's a natural opportunity to encourage a bequest and do it at the same time. And it's a really easy way to raise the estate planning topic. Gee, do you know that the law says that when you pass away, this stuff is gone? Most of us don't realize it. Now, the fiduciary has sole authority to handle those digital assets, which means the sole authority to delete digital assets. So that photograph that you prepared that never should see the light of day, the fiduciary can destroy that. Now, the individual can and should provide guidance to the executor or trustee, and often that's a really good idea. And the fiduciary is still subject to privacy laws, and they still must act as a fiduciary. So you can impose some guidelines, some suggestions, and that's a great thing to do. What we also know is how will companies comply? Well, they can provide a password, but more likely they're going to give you a copy of the account or asset or file instead. Well, the important thing is state courts can now compel them to do this. It used to be the state courts said, no, we can't. What do they need? They're going to need your email address, username, some means to identify your account. You can't simply say, Facebook, give me everything about John Jensen. They're not going to respond. You got to give them more information than that. Now, what we also know is that they can change their minds, and the timing is also important to understand. If you authorize in writing your fiduciary to have access today, and the law in your state doesn't get passed for 6 months, it's still valid, it still works. And the decision can be changed at any time, either in writing or on the internet, over line. Your donors will thank you. Help your donors. Give them a reason to update their will. They all know it needs to be done. They all know that their will needs to be updated. They just haven't gotten around to it. This is a reason to help them do it. This is a map that shows the states that have adopted it. The gray-blue have adopted it. The green are in process or under consideration. The white have not done it. California, I'm guessing the tech companies are just so strong they don't want this to pass, so it hasn't. They've got something out there that doesn't work terribly well, but that'll get fixed in time. Happy to talk with folks about this afterwards, and thank you for your time.